Hello, everyone. Eric from Helps on YouTube Live today, Monday, November 17th. I'm at a different location. You'll see me here again, hopefully more often. But if you can hear me, let me know on the chat feature, okay? And if you have any questions, you can put them on the chat. I'll try to address them. Should be able to get them answered. Okay. I just got off the phone with someone from Chicago, and I promised her I would talk about timeshares right at the beginning. Okay. This person has limited income, Social Security, and a pension, has some equity in her home, and but got wrapped up with a timeshare. Timeshare salesman, thanks for letting me know you can hear me, Kathy. They can be very persuasive or high pressure. Okay. I was subject to that one time. I didn't buy a timeshare, but years ago, because I've dealt with people with timeshares. And one thing I didn't tell her, which I'll tell you, I probably filed 30, 40,000 bankruptcies before Helps was started. And a couple of years ago, I asked one of my partners, I said, do you guys ever remember in the history of our practice that a timeshare ever sued one of our clients? And they all agree with me. No, we could never remember when any of our clients was ever sued for a timeshare. The timeshare just wants to get the timeshare back so they can sell it to someone else. Now, it's theoretically possible that they could sue, but it's not their practice to do that. Especially, I think, for seniors, because, if your income, Social Security, or pension is protected, no one can take it. Okay. So I told this person I just talked to, just stop making the payment on the timeshare. Now it's coming out of her check automatically. I said, contact the bank. You can contact the timeshare place and have them stop it, but you might be better luck having the bank stop it. Okay. If it's a credit card and you want to stop, they'll stop it automatically. But a timeshare is more of a high pressure place. They might give you a hard time, and so you can contact the bank and put a stop payment on it. Don't need to pay it anymore, and they're not going to be able to collect from this person. Now, this person, they had some other debt, but not a whole lot. And if they didn't want to have to deal with the timeshare people, they could enroll in Helps. We sent a letter to the timeshare company, let them know that this person's income is Social Security and a pension. She's not going to pay it. That's going to be the end of it. Okay. Now, sometimes the timeshare will send you a letter saying, okay, give us your timeshare back, but sign this form and give us $1,000. And I tell people, I said, well, you can sign the form and send it back to them. That way they get the timeshare. But don't worry about the $1,000. Don't pay that. They don't need that. They're going to be glad to get the paperwork back. And then I talked to another guy, in fact, last week, about a timeshare. And he owned it free and clear. But he was really convinced he could sell it and get money for it. And I told him, I said, well, you can try, but I can guarantee you no one's going to buy that timeshare from you. And there may be companies that try to get you to give the timeshare to them so they can sell it for you. But if you do that, they're going to charge you money up front for them to try to sell it. And in the end, you're going to find out that no, you weren't able to sell it. They're not, but instead you paid them money for doing something they were never able to do in the first place. And then I remember talking to a guy who bought timeshares in Mexico. Ended up spending tens of thousands of dollars trying to get out of this timeshare. He just got suckered into this company in Mexico that told him he had to do this thing or that thing and send him money after money. So no, if you've got a timeshare, you don't need to keep it. Now, the problem with timeshares, even if you own it free and clear, is they charge you a monthly. They charge you a fee, even if you own it, to stay there. And sometimes that fee is equivalent to what it would cost you to rent the place for a year, for the week you stay there or the 2 weeks. So it's not usually a very good investment, timeshares are. Now, some people might argue with me, but I'm just thinking, that's my opinion, and a lot of people share that opinion. And if you're a senior that can't afford it, you don't have to keep paying on that timeshare. So I've said my spill about timeshares for the day. But you don't need to worry. A lot of people do have that issue. Okay. So I'll go on from here. You can put your questions in the chat and I'll try to address them there. So this person contacts us. They have $40,000 in debt on Social Security, disability, and they get a civil service pension and workers' comp. So the civil service pension is protected. If it's a federal pension, that's just like Social Security. And twice the amount they get in the federal pension is automatically protected from garnishment in the event they were sued and someone tried to garnish the bank account. But no one can take the civil service pension, no one can take the workers' comp. And twice the amount of your federal benefit deposit in your bank account is protected. So if they get Social Security, disability, and a federal civil service pension, twice that sum is protected, even if other monies are in there. Okay? So if you got Social Security, for example, of $2,000 a month, 2,000 times 2 is 4,000. 4,000 in your bank account is protected automatically. In the event someone were to sue you, get a judgment, attempt to garnish your wages, your bank will protect that without you having to do anything. Okay? So this person contacts us and gives their name and says, I'm a 74-year-old widow living on Social Security of $1,856 a month and no extra income coming in and no assets or savings. I can't afford my debt payments anymore. And they say, I was within Green Path Credit Counseling Program for the last 4 months, but I could not keep up with the payments anymore because the amount was too high, $900 a month. Okay, she got $1,856, so half her income was going to pay Green Path. Now, the question I have, did Green Path tell her, by the way, your only income is Social Security, it's protected, no one can take it, you don't need to enroll with this? I can assure you they didn't tell her that. Virtually none of these companies will tell a senior that. Instead, they end up enrolling seniors, making payments they can't afford, putting many of them into utter poverty, okay? So she could stop making this payment. So let's go on and say what it says, okay? Which was half my Social Security. I want to make sure my Social Security stays protected. It is protected. No one can touch your Social Security. And like I said, even if they were to sue you and get a judgment, half the Social Security you get each month is protected by your bank without you having to do anything from garnishment. And if you got like almost $1,900 a month, twice that would be $3,800, is protected automatically in your bank account, even if some money in there came from another source. Okay? This person says, I owe around $35,000 in credit card debt. I heard that helps seniors like me who can't pay their debt. I wanted to ask about your program, what steps I needed to get started. I look forward to hearing back from you. So yeah, if you're like that person and you have debt you can't afford to pay and you're a senior on Social Security or pension, disability, VA benefit, or workers' comp, any type of this protected income, you can stop paying your debt. If you don't want to hear from the creditors, you can call us. We can talk to you. And if you enroll in HELPS, what we're going to do is send a cease and desist letter out to the collectors you owe money to, and they're simply going to leave you alone. You're not going to need to worry about it. Okay? I'm going to try to mute my phone. There we go. Okay. So let's see if we got some questions I can deal with here. So Rhonda says, not true. State of Nebraska garnished my banking amount up to my disability. Okay, well, let me explain this to you. Okay? The amount that's protected in your bank account automatically by your bank is any money that you get from a federal source. Okay, which would be Social Security, a federal pension like Office of Personnel Management, a railroad retirement, or a U.S. Post Office. Those are all federal pensions. That amount deposited in your checking account is deposited automatically from garnishment by your bank without you having to do anything. Now, if you had other money that was going in there, that would be protected too, as long as the total sum in the bank account is less than the amount that you get for your federal source. So in Nebraska, if you have a bank account in which your disability goes, and it's not a federal benefit, it is possible for the state to try to garnish that. But I'm pretty sure there's an exemption for that under state law, and you can file a challenge to garnishment or claim of exemption. But you're not going to tell me that there was federal money that went in there and that your account was less than twice the amount of your federal money and that money got garnished. Okay. And if you do tell me that, then your bank made a mistake, but I extremely doubt they did. Now, when this rule went into effect in 2012, it took a while for the banks to get on board. They got on board pretty quick. It took a longer while for the credit unions to get on board. But we deal with thousands of seniors, and their income is not garnished after there's a judgment, okay, including for state taxes that are owed. But if you have an account into which a disability goes that's not a federal benefit, then yeah, they can get at that money. But once again, you can file a challenge to garnishment or claim exemption and to get that money back. But it's best to just keep it out of there, so that way they wouldn't have access to it. Okay. Eric, did you tell us before that getting a settlement will be protected also? Well, it matters what kind of settlement. Different states have different laws. Most states will protect a settlement for an injury case, like a car case. But the question is, it protected automatically in your bank account when it's deposited there? Normally, that's not the case. You'd have to, if someone, but you wouldn't have to worry about it unless someone sued you and got a judgment. They happen to know where you bank, and then they garnished your bank account. Then you'd have to file some paperwork with the court, claim exemption, or challenge the garnishment to get the court to order that money be returned. But you can prevent the problem from happening is if you have a judgment, is just keep it out of the bank account, or make sure that the amount in the bank account is less than twice the amount of the federal benefits. Make sense? Okay. But put questions on here if you got any. Let people know that debt collectors can sell your debt beyond the statute of limitations, some up to 20 years. Well, I talked about that a couple of times. It doesn't happen that often, but a statute of limitations has to do with when a creditor can legally sue you, and that's under state law. A common might be 6 years to file a lawsuit from either the debt was incurred or when you last made a payment. But just because the statute of limitations for them suing you doesn't mean they can't still try to call you on the phone and get you to pay. Sometimes they'll do that. And occasionally, rarely, I'll hear of someone calling me and they'll talk to me and say, I got a call from the collector, for a debt I owed 20 years ago trying to collect. Well, that's pretty uncommon, but they can't. In fact, I told this, I think yesterday or the day before, a person sent me a letter from a debt collector for a 20-year-old debt. And then the last sentence said, by the way, we can't sue you on this debt, but we'd like you to pay us. Anyway, something, words to that effect. Okay. So this person contacts us from it's like Texas. They're 77. They have 1,700 in income, 33,000 in debt, and it looks like they get some other income, Air Force retirement, and a small pension. And they bank at a credit union, but they don't owe any money to the credit union. That's important. We ask about where you bank, okay? And if you owe money to a credit union and you bank at a credit union and you're not going to pay the credit union, we're going to tell you to change to a different bank account. Because a credit union can do they can offset money out of your bank account to pay the debt you owe them. So if you have a credit union account and you're not going to pay the credit union, you're going to want to change to a different bank. The person says they're buying a home only in my wife's name. There's 2 cars in his name. They're paid off, older cars. And then he owes some debt. He's got an illness, can't pay the debt anymore. We read him what we did, read him what the cost was, answered his questions, and he enrolled, and he was relieved, so he didn't have to worry about the debt. The debt was in his name. when he passes on, his wife won't be responsible for his debt, assuming he passes before she does. So this person contacts us from California, and it says they called in with her big brother on the line, who doesn't have her power of attorney but helps her. And yeah, we'll always be glad to talk with someone and another family member. We do that a lot. And he said that she wanted to give permission for Helps to speak with him on her behalf if she decides to enroll. She had a stroke in 2024 that affected her mobility and cognition to a degree. She lost her job and had to surrender her car and had some credit card debt. And she moved in with her mom, who receives only Social Security. She applied for Social Security disability, which she'll probably get automatically if she hasn't already. Oh. And the paralegal, the attorney says, gives their name, are incredibly kind and so nice to speak with. And the brother is very frustrated with how little creditors cared that his sister always paid her bills on time prior to a major medical event. He says he was so thankful to hear about helps from his friend. We read what we did. And there's not going to be charged a fee until she gets her Social Security disabilities approved. And sent them some emails and enrolled them in help. So we're going to send a cease and desist letter out to this person, stroke victims, creditors, so they leave her alone. And that's what we do. We don't turn anyone away that needs our help. So this person contacts us. They had an RV that went back, and they have a deficiency of about almost $70,000. The wife was talking to us on the phone. The husband was bedridden and is very sick. And it says her husband owns the home. It's only in his name. And she asked, can I get kicked out if there's a lien on the home and he has passed? James has a will. Is this my protection? Well, okay. I don't know where they live, but in most states, they've been married for a while. They should seriously think about adding the wife's name to the home as a joint tenant with rights of survivorship. That way, he's very sick. If he were to pass away, then the home is going to go to the wife and any debt that the husband owes, because apparently the debt on the RV is owed by him. And if when he passes away before she does, assuming he does, then the home will automatically go to her, and she won't have to worry about this debt on this RV. Okay? Don't need to worry about it. So, questions, you put them on the chat feature and I'll try to address them. Okay, so Rhonda says I think this is from Nebraska. It was only my disability, nothing else. Nothing else in my disability, nothing else in my account. There's nothing else in my account. Well, then they could garnish it, you should be able to file what's called a challenge to garnishment or claim exemption, have that money returned, as long as it hasn't been too long. You'd want to get on it right away. You see, Social Security is protected, so is pension, so is disability, so are VA benefits, workers' comp. And we're talking about automatic protections in the event someone were to sue you and get a judgment. How your bank protects that automatically. But if you have an income that's protected, but not protected automatically, you can still file paperwork with the court to have the court order that money be released and returned to you. And I can't imagine Nebraska doesn't protect disability. Why would they give someone disability income they need it to survive, and then let a creditor take it. Well, they wouldn't. So there's a state law that's going to protect your disability. And if they've done this recently, I mean, if you're a member of HELPS, contact us. We can get you, point you to the form, but you need to file challenge and garnishment or claim of exemption to get that returned. Okay. Now, if it happened 2 months ago or 6 months ago or a month ago, or it's been too long, then it may be too late to get it back. Yeah, there's usually a time limit under state law for you to petition the court to have money returned that's exempt. But when I talk about money that's protected, I'm talking about it's protected, but then there's automatic protection in your bank account. Two different protections. Okay. So Rico says, don't be surprised or offended by credit card companies for lack of emotions about your personal troubles. It's a computer following the program. Yeah, it is. And then the next question has to do, what about my 401k? So it's protected. No one can garnish your 401k or your IRA, independent retirement account. Okay, no one can take it. They can't take it out of that. Now, when you take it and deposit in your bank account, you want to make sure that the amount you put in your bank account, the total sum, is less than twice the amount of what you get in federal benefits or twice the amount in your Social Security. Otherwise, if it was more than that, it's still protected. You'd have to file a challenge to garnishment to get it released. So we're talking about automatic protections on one hand, and then general protections on the other hand. But no one can go after your 401k directly or your IRA. It's going to be safe. Okay, let me get here. Person calls us from South Carolina. Let's see what they have to say. I'm on YouTube. Jeez. This person contacts us from Oregon. And both receive Social Security, and the husband works 1 day a week and gets wages. So they have a joint bank account, they rent, they have one car outright, and they have another car they can't afford, they're going to surrender. And it looks like and then recently they called and say they surrendered the vehicle. They live in a travel trailer that they rent the property on, which is protected. No one's gonna. So here's the deal. This person essentially, they get Social Security and he works. The question is, because he works, is that income going to be at risk? Well, probably not, because he works 1 day a week. Now, and depending on what state you live in, you can make an unlimited amount of wages. For example, Texas doesn't permit garnishment of wages. Okay. But in every state, there's a federal law that protects $217.50 net per week in wages. It's $435 every 2 weeks, about $950 a month. So, but then a lot of states protect more than that. Like California protects like $600 or $700 a week. Nevada $400. It depends on the state where you live. South Carolina, almost impossible to garnish wages there. It depends on the state, but in every state, the minimum amount is the federal amount protected, which is $217.50. But we don't run into problems with our clients getting garnished. Most of our clients aren't working. Those that do work, a creditor would have to sue them, get a judgment, which is itself maybe not terribly likely. Then they'd have to know where they work. And it's not always easy to know where someone works. You can't go to a website and find out where someone works. So we're going to be telling this guy that he doesn't need to worry. He's going to be fine. Okay. So this person calls us from Alabama, getting sued by a community bank, by Midland, and by Citibank. Want to know about the statute of limitations. And we explained to him what it was, and that if you make a payment on a debt, then that starts the statute of limitations up again. So, um, if you have a debt, it usually, most state laws, you get the statute of limitations run from when either the debt was incurred or when you last made a payment. So if you had a debt that was 5 years old and then you made a payment last month, then they've got another, and the statute of limitations is 5 years, they've got another 5 years to sue you. But once again, if you're on Social Security or a pension, your income's protected. Doesn't matter. They're not going to be able to collect from you, so don't need to worry if you've done that. Okay. This person asks us, what about annuities? I have a very small one from Cornell University. I've had it for 32 years. It's a lifetime annuity, which I didn't put any money into it. Well, an annuity is almost like a pension, and it's going to be protected under a state law. I can't recall ever in my practice of 46 years of someone coming to me and telling me that their annuity was garnished. Although I know some states do limit the amount that you can get in an annuity that's protected automatically from creditors. But no, I'm going to tell this person he's got a small, he's a very small one. So I'm sure the state where he lives is going to protect that annuity. He's not going to need to worry about it. So then this person contacts us and says, will I be able to rent an apartment with debt in collections? I should be able to. I'll explain. We have a form letter that we'll give to anyone. It's called a landlord letter that explains to a prospective landlord that even if you have negative entries on your credit, that all your income, your Social Security, your pension is protected, can't be taken from you. It's available for your needs, and including to pay rent. And we tell persons that want that letter to show that letter to a prospective landlord, because a lot of prospective landlords don't understand that your Social Security and your pension is protected and no one can take it, and that it will always be available to pay rent. So, but once in a while, if you show it to the landlord, then they can say, well, okay, this will be fine, yeah. But if they charge an application fee, they might be able to tell you, oh, don't pay the application fee because we're run by a corporation and we have corporation rules. So you could save the application fee. That's called a landlord letter, and we'll give it to anyone that needs it. Okay. Should understand too that, when you enroll in HELPS, we do have a program called 7 Steps to a 720 credit score. You can rebuild your credit after you enroll in HELPS. We help people do that. So this person calls us from Kansas, and they're younger, unless they're on Social Security disability, and they're a daughter of a client. They're not current on the debt. It says they're struggling with credit card and a dental debt, and they're being sued by Celtic Bank on a credit card. It says, we explain what we did, what we do, how her Social Security disability is protected. She doesn't need to worry about the lawsuit. And she says, we'll send in the summons once she enrolls. and her income is approximately like $1,500. So no one can take it. The fact that she's been sued, they can't collect from her. So I talked to this guy this morning, and he wanted to know, how long do I need to worry about money in my bank account? I'm getting some loan proceeds. And I said, first off, you don't need to worry at all unless someone sued you and had a judgment. And then I looked at the file, and he was a client. It looks like someone had sued him, but it'd been a couple of years ago, and he hadn't heard boo from him. And I said, well, to be safe, you'd want to keep, you know, the amount in your bank account less than twice the amount of your federal benefits. But it's been a couple of years ago. The chance of them garnishing your bank account is probably pretty remote. But if you're going to get some money that wasn't protected federally, like a pension or Social Security or some type of other protected money under state law, to be safe, you'd want to keep it out of the bank account. Now, the older the case is, less likely is they would choose to garnish, okay, as a practical matter. But to be safe. And so he said, what he was worried about, he was getting some loan proceeds, and that wouldn't be exempt. And so if he put that into his bank account, and they did happen to garnish at that time, he could lose that money. And I said, the safe way to do it is when you get the loan proceeds, just turn it into cash. Okay? And that's what he thinks he was going to do. Okay, let's see if we got some questions to deal with. Okay. Turbo says, a few of us seen and commented on your interview with Senior Living the other day. I see that, and that was very nice of you to do that. Thank you. I saw that this morning. I appreciate it. I thought the interview went good. We're going to do another one here real quick. He says, I'm leery of 401ks now as the government has so much debt that they can't pay back and will come looking for their taxes in a 401 one day. I kind of doubt it, but okay, my opinion. So it's Marley says that they got a judgment from Capital One back in August, but I haven't heard since. Does it mean they're not pursuing it further? Well, okay. If you're a helps client and someone sues you, we ask you to get us a copy of the lawsuit. We usually need the first 2 or 3 pages, or 3 or 4 pages. And then we're going to send a letter to the attorney who sued you and let the attorney know that your income is protected and you can't pay the debt. Okay? And eventually, normally the creditor is just going to get a judgment. Sometimes they're going to send you a notice that they got the judgment. Sometimes they might not even send you a copy of it. They just get a judgment. But it's not unusual for them. They got a letter from us saying that your income is protected. You're not going to pay it. A lot of times they don't bother with trying to do anything else. I mean, they could try to garnish if they knew where you bank, but a lot of times they don't do that because they figure it's a waste of time. So I guess I'm not surprised that they haven't contacted you. Okay? But it was only in August. These things take time. September, October, November. You could be getting something here, but I wouldn't worry about it. As long as you keep the amount in your bank account list, twice about what you get your federal benefits, it's going to be protected. Okay? Banks don't give credit out of the goodness of their hearts. It's a calculated business gamble on their part. If they can't hold up your end, don't feel guilty. You had no ill intent. They took the chance. That's why they charge interest. Is it double your Social Security take-home protected or Social Security and pension? Well, it's all protected. Remember, no one can take it. Okay. But the amount that's protected automatically in your bank account from garnishment in the event someone were to sue you is twice the amount of your federal benefit. So if your pension was a federal pension, like you worked for the federal government or a railroad or post office or VA, then twice that plus Social Security would be protected. But if it was a private pension, then no, it's twice the amount of your Social Security is automatically protected. Even if the pension went into there, as long as the amount in the bank account is less than twice the amount of what your federal benefit you get each month, it's protected. Got it? What about child support garnishments from Social Security disability payments? Do they collect them straight out of Social Security to you, the bank, or both? I don't see them going after the bank. I see them going to, and I don't see this very often, extremely rarely. But they can garnish 50, even up to 60% of your Social Security for past due child support. We don't run into too many seniors with this issue. If you do have this issue, you can call Helps and talk to me personally. I'll go over it. There may be a couple of solutions, partial solutions that could help you. Okay. So Dribble says, like in Pennsylvania, judgment sets for 5 years. It can be renewed. That's pretty typical. Judgment's good for 5 years, and then it can be renewed. A creditor would have to file paperwork to get it renewed. Okay, let's see how we're doing here. Person from Texas. I received letters from a lawyer that they learned from the county clerk's office that Chase Bank had filed a lawsuit against me. I live on Social Security only. Please help. Okay. It's a lot of bankruptcy attorneys subscribe to a service that lets them know if someone was sued in the area where they practice, like the county where they practice law. And they'll send an advertising letter out to someone that's been sued, letting that person know that, hey, you've been sued. We can help you. We do bankruptcy. And sometimes I'll talk to some clients, they'll get 2, 3, or 4 or 5 of those letters from different attorneys letting them know they've been sued. A lot of times they'll get a letter from an attorney saying they've been sued even before they've been served with a summons. Okay? So, once again, if your income is Social Security or pension, you don't need to worry about it. They can't collect from you. But that's why you got that letter. It was just an advertisement from an attorney who filed bankruptcy. They can do that now. Okay? This person has 40,000 from Social Security. He's on Social Security disability, civil service pension, workers' comp. All that money's protected. He doesn't need to worry about the 40,000 in debt. And contact us. We can protect him. This person says, I owe IRS an unknown amount from the past few years. Says, I'm not worried about credit cards at this time. Okay, well, if you have lower income, you can often qualify for what's called CNC status with the IRS. That stands for currently not collectible status with the IRS. And sometimes if you can apply for that on the phone, if you got a notice from the IRS, in upper right-hand corner, there'll be a number. You can call that number. You can be on hold for an hour and a half for them to pick it up. And the closer you are to the poverty level, the easier it is to get on currently not collectible status over the phone. Now, generally, you could get on currently not collectible status if you have income. You're single, about 2,500 or less, or 3,500 or less if you're a couple. But if your only income is Social Security, and you get a notice from the IRS and you owe them some taxes, they may never do anything except send you that notice. The worst the IRS can do, normally would be to send you a letter saying they intend to offset 15% of your Social Security. Okay. So if you got a 2,000 Social Security, they could offset $300. That's 15%. But they want to do that for 60 days, and that would give you time to contact the IRS to apply for currently not collectible status, or make arrangements to pay. You can get on the, we have emails that tells you how you can get on their website and pay the IRS. You can pay them over 5 or 6 years. If you owe $10,000, the payment would be about $200 a month or less. So, I mean, you can pay your, nothing wrong with paying your taxes. We should do that. But if you're having to go without basic needs, the IRS has a provision for you to get on currently not collectible status, so you don't have to pay the tax. So this person contacts us. I have a debt situation with a certain debt collector. I receive about $12.50 a month in Social Security, and I get about $300 a week from a part-time job. Looking to protect myself the best I can. Have a total of about $50,000 in unsecured debt. Well, okay, I didn't know where that person lives. Like I said, in some states, garnishment of wages aren't permitted. In other states, protect a certain amount. In every single state, at least $217.50 net per week is protected in garnishment. Okay, and that may be the case with this person. So they're not saying that they've been sued. They just owe the money. Okay, they may never get sued. When people enroll in helps, we send a cease and desist letter out to the creditors you owe money to, let them know your income's protected. Probably makes it less likely they would sue you. They could still sue, but even if they sue and got a judgment, in order for them to do anything, they have to know where you work, and that's not always easy to do. So we don't run into too many of our clients have a problem with having their wages, if they have a little income, being garnished. Person contacts us, says, is it possible to schedule a phone appointment? I'm disabled on Social Security and need help badly with my debt. I'm not free until later this week. And you really don't need a phone appointment. You know, you can call any time, and we've got paralegals and attorneys ready to talk to you at any point. So if you're listening to me and some of this stuff sounds like it can make sense for you, you know, call our number. We'll be glad to go over it with you. Okay, let's see if I've got some questions here that I can deal with. So we talked about child support. How do they verify your income? The bank? Pretty easy. When anything gets deposited, like Social Security gets deposited in your bank account, there's a code on the deposit, and there's a department of the bank that deals with garnishments, and they look at that code. If it came from a federal source, then they know to times that times two and protect that. Once again, your bank manager doesn't understand that rule, and probably 999 out of 1,000 attorneys don't know that rule yet, even though it's been in effect since 2012. Bank managers don't know the rule because they never deal with garnishments. Do we provide your helps firm with verified income, or will the person suing you will ask for proof? So when you enroll in helps, you know, you enroll over the phone. Okay, we click a button and we keep you on the line. You get an email that says welcome to helps. And then we send you a follow-up letter too. And one of the things we're going to ask you is to send us proof of your income. Now, we don't need that in order to represent you. that's something that you would get us follow up, because once in a while, a debt collector contacts us and says, okay, we got this letter from cease and desist letter, but we'd like you to give us proof that their income and Social Security is protected. So it's nice if we have your Social Security statement where you get in our file that we can, black out the personal information. Then we send that to them to let them know that your income is Social Security is protected. I think it makes it less likely they would choose to sue you. Okay, and so that's what we do. Let's see here. I have our Social Security and pension deposited to our credit union checking. If I transfer Social Security money from my checking to savings at this credit union, is that money protected in the savings? Thank you. No, it is not. Now, because it isn't money that was deposited directly from Social Security into your savings account. So that's why I tell people, if you've been sued, you should only have one account, and that's the account, your checking account, where the Social Security gets deposited. You don't get that much in saving money from your savings account anyway. That mattered a hill of beans. Now, if you did have a sizable sum in your savings account that came from Social Security and it happened to get garnished, then you could file a challenge to garnishment claim exemption and show the court where that money in the savings account originally came from Social Security, and the court's going to order that be released. Okay. Is the Social Security amount protected based on your gross amount before Medicare, or the net amount? The bank, they don't know what your gross amount is. They just protect twice the net amount that's deposited in your account. So if the net amount is $1,500 deposited in your account, $3,000 is protected, twice the amount. Okay. Hold on here. Whoops. I'm sorry, I can't. I'm reading this. Okay. Person says they're being billed by AARP for doctor visits and he can't pay. He thought he was covered under some insurance plan. They're telling him not on the plan that he has. He's since changed his plan, so it will now cover any cost after Medicaid or Medicare. We talked to him about asking for a financial discharge. He has only medical. He lives in an assisted living facility, and it takes all of his income, and the Medicaid pays the rest. Okay, so here's the deal. If you enroll in health, you give us the credit you owe money to, including any medical debt. But if it's a doctor that you use your normal doctor, we normally would tell you not to give that to us. Because that'd be like rubbing salt in a wound. You'd saying, okay, I'm not going to pay you, but you keep seeing me. But if you do owe your doctor some money and you can't pay him, then pay him, a token amount, $5, $10, $15, whatever you can afford, something small. And I don't see doctors cutting people off if they're trying to pay them. Okay? So this person contacts us and says, I'm receiving Social Security, retirement, and a small pension, approximately like $1,100 a month. I get credit card debt and thought I could manage, but now at the point that my debt payments leave me no money at the end of the month. I'm making minimum payments. Would appreciate any advice you can provide. Sure. It's like you dug a hole and you're at the bottom and you're trying to throw the dirt out of the hole, but it keeps coming down. In other words, you've racked up enough debt that you can't keep up with the debt. You can stop paying it, okay? And you can use that money for your needs, for your food and your medicine. And if you don't want to hear from the debt collectors, you can enroll in helps. We're going to send them a cease and desist letter. They're going to leave you alone. So remember, your Social Security, your pension is protected. No one can take it. And the lawmakers protected it because they wanted you to have enough money to pay for your needs, for your food, your medicine, and your basic needs: heat, rent, air conditioning, whatever it is. Okay? So this person contacts us and they say, I haven't filed my taxes since about 2014. I've not received anything from the IRS questioning me about it. Should I just wait for them to contact me and lay low? Thank you for your assistance. I'm 68. Okay. Well, okay, I don't know how long you've been on Social Security for. I can't tell someone not to file their taxes. By law, we're supposed to do that. But the IRS may never do anything in this particular case. Sometimes you don't want to kick a sleeping dog, right? This person writes us and they say, I'm trying to get help with the summons I received from the court today for a lawsuit from a debt collector. Well, we don't represent people in court. I got the yawns today. I'm sorry. I got the yawns. Most of our clients are on Social Security, disability, VA benefits. Their income is protected, and they owe the money, and they don't need to. They don't need to dispute the debt. If someone gets a judgment, no one can collect from them. So, yeah, if you're sued and a summons and it says you're supposed to go to date at a court at a certain date and time, I mean, you can defend yourself if you want, if you don't owe the debt. But if you owe the debt, then defend yourself could just kind of be embarrassing. Okay, this person contacts us. I've been hospitalized for several months. Sadly, I'm unable to speak due to a large something with my throat. How can I proceed to protect my Social Security and pension? We don't need to do anything to proceed to protect. It's protected automatically for you, okay? You don't need to notify the bank and say, my income's this, protect it for me. No, the bank will protect twice the amount of your federal benefit automatically. So this person contacts us and she says that her husband passed away. They co-signed on an RV and she can't make the payments anymore. She can't sell it for what it's worth or what she owes. We talked about how to surrender the RV. We have an email that goes that into detail. And what we tell people, if you have an RV that's going to go back, you can't make the payment, don't just call the lender and say you're going to surrender it. Wait till the payment's behind and they call you. Because if you call them out of the blue when it's current, person you talk to, you're going to know what to do. But if it's behind and the person calls you, that person will know what to do if you're not going to keep it. If she surrenders, she says she's interested in letting the RV go back. It'll save her a lot of money. And we sent her an email on how to do that, why she didn't need to work. So what I'll eventually do in the RV, sometimes it takes longer for an RV to get repossessed. but they're going to eventually pick it up. They're going to sell it. And then they're going to send you a letter saying the difference you owe between what you owe on the RV and what they got. And usually you don't, what they sell it for isn't enough to cover the debt. But that difference is called a deficiency. They're going to send you a letter called a deficiency notice. And when you get that, if you're a member of HELPS, you get that to HELPS. We're going to send a letter to that lender explaining that your income is Social Security, you're not going to pay it. And that's the end of it. You don't need to worry. Okay. Okay, there's some questions I should deal with here. So this person says, I would have Social Security deposit into a bank account and transfer to a credit union. I think Eric mentioned the other day to not use credit unions. No, you can use a credit union, but you should have your Social Security go directly into the credit union. The only time I tell you not to use a credit union is if you owe money to the credit union and you're not going to pay it. Then in that case, they can do a set off and take money out of your credit union account to pay your debt. You gave them permission to do that, whether you realize it or not. What if the court records show they claim non-service of summons? Is there a penalty? No. They claim I have plants blocking my entrance. Good for you. Some people have a gate. No, there's no penalty if they can't serve you the summons. No. You don't have to make it easier on them. Claimed hostile environment from Kitty. I've never heard of that one before. Okay. This person calls us, they say 72 years old and 3 credit cards with a balance of like $30,000. And I've reached a place I can't even make the minimum payments. Yeah. Contact us. We can send them a letter. They're going to leave you alone. So this person, and looks like we've virtually run out of time. So I'm going to end it there. See if there are any more questions. No, there's no penalty. No hostile environment penalty that I've heard of. If you have any questions, call us. You can put them in the comment section on this video, and I'll answer them there. If you like the video, please press the like button, subscribe to our channel. And once again, if you have any questions, call us toll free 855-435-7787. You're going to be fine. And we're glad to help you. God bless, and I will talk to you same time tomorrow. Bye.